Hello friends, welcome to my channel. Today I'm going to deal with interpretation of penal statutes. The principle that a statute enacting an offense or imposing a penalty is to be strictly construed. The word strictly is used here. Strictly construed is not of universal application. Not of universal application means there may be some exceptions which must necessarily be observed in every case. It is now only of limited application and it serves limited application. So not universal application. So it is not of universal application means there may be certain exceptions, and it is now only of limited application, and it serves in the section of one when selection of one, when two or more constructions are reasonably open, when there are two or more possibilities are reasonably open, two or more constructions or interpretations are reasonably open, and then it is in the selection step. It serves in the selection step one when two or more constructions are reasonably open. The rule was originally evolved to mitigate and rigor of monstrous sentence or trivial offenses, and although that necessity and that strictness has now almost vanished, the difference in approach made to a penal statute as against any other statute is still persists. The difference in approach made to a penal statute as against any other statute still persists. So according to Lord Isher Emmer, the settled rule of construction of penal statute, penal sections is that if there is a reasonable interpretation which will avoid the penalty in any particular case, we must adopt this construction, avoid the penalty. If there are two reasonable constructions, we must give the more lenient one. So penal statute means the statute which imposes penalty. That means provides punishment. For example, we can give an example. IPC, Indian Penal Code, is an example of a penal statute. So here in this case, Lord Isher said that if there is reasonable interpretation which avoids the penalty in any particular case, we must adopt the constructions which avoids the penalty. Means because penalty, it is penal statute, so it is a serious kind of statute. That's why it avoids the penalties must be construed as such. Then comes interpretation of penal provisions must be in consonance with the principle underlying fundamental rights. So it must be consistent with the principles underlying fundamental rights. Fundamental rights are human rights, which is declared as Universal Declaration of Human Rights. So any provision which visits an accused with adverse consequences without affording him any remedy to disprove an item of evidence which stands against his innocence is inconsistent with philosophy enshrined in Article 21. Article 21 provides right to life and liberty. So if it is against, then it must not be. If it is inconsistent, then it must be avoided. It was held by the Supreme Court that it should so interpret just provisions as to dilute it to make it amendable to Article 21 of the Constitution. For example, we see in CRPC or any other statute, it is in consonance with Article 21. Not only this, but it is in consonance with fundamental rights. IPC also is in consonance with fundamental rights. For example, a person is presumed to be innocent until proved contrary. So it must stand the test of constitutionality, constitutional validity. It must not be against the fundamental rights, that is human rights. It must be against to fundamental rights. Right to life and liberty is provided under Article 21 of the Indian Constitution. When words employed in a penal statute are not clear in the principle against double penalization, this may be provided under Article 22 subsection 3 probably. Article 22. So against double penalizations, this will be Article 22 subsection 2. I forget the exact section. So will be applied. Failure to comply with a statute may attract penalty. Failure to comply with a statute may attract penalty, but only because the statute attracts penalty for failure to comply with the statutory provisions. The same in law situation will not call for strict construction. So it will not call for strict construction because these are penal statutes. These are of serious nature, so there must not be such thing like strict construction. This must be construed in accordance with fundamental rights. Then comes an interpretation which strikes a balance between enforcement of law and protections to valuable human rights of accused. Right to privacy must be restored to. For example, Section 105 of the Evidence Act 1872 says that burden of proof that the case of the accused falls within an exceptions to the statutory offence lies on him. But the question whether the defence set up by the accused is really a defence of an exception or a defence setting up non-existence of a fact which is an ingredient of the offence to be proved by the prosecution. It to be proved by the prosecution depends upon the construction of a particular statute. So then comes in applying the interpretation of a penal statute public policy, also taking into consideration not only Article 21 or FRA fundamental rights, but also public policy is taken into considerations. In a recent case, the House of Lords held that consensual sadomasochistic homosexual encounters which occasions actual bodily harm to the victim or assault occasions actually bodily harm contrary to Section 47 of the Offences Against Persons Act 1861. So in Britain there is an act called Offences Against Persons Act 1861. So it is against for Section 47 is given under Offences Against a Persons Act 1861. So the kinds of offence mentioned here, that is consensual sadomasochistic homosexual encounters which occasions sexual bodily harm to the victim, were occasionally actual bodily harm. Contrary means against or in violations of Section 47 of Offences Against Persons Act 1861, and unlawful wounding contrary to Section 20 of the same act. Notwithstanding the victim consents, here we see the word consensual. But notwithstanding the victim consents to the act inflicted on him. The following are the some of the propositions important in relation to strict construction of penal statutes. So as we know, penal statutes should be construed strictly. If the scope of prohibitory, not mandatory, prohibitory works to cover only some class of persons or some well-defined activity, their scope cannot be extended to cover more on considerations of policy or object of the statute. Because if we consider the policy or object of the statute, and in the case of welfare legislation, this is different. In case of welfare legislation, while interpreting, they need to give effect to the object or intention of the legislation as to further the welfare policy. Okay, but in case of penal statute, because which involves penalty or certain kind of punishment, that's why it should be construed strictly, and it should not be construed keeping in view of the object of the legislations, because whatever written in the statute, it should be interpreted in its literal meaning and not liberally. Prohibitory words can be widely construed if it indicated in the statute, only if it is indicated in the statute. On the other hand, if after full considerations no indication is found, the benefit of construction will be given to the subject. Then point C, if prohibitory words in their own significations bear wider meaning in their own signification, which also fits in with the object or policy of the statute. Then we find a case J.K. Bombay LTD versus Bharati Matha Mishra. J.K. Bombay LTD versus Bharati Matha Matha Mishra. So in this case, it was held that the expression officer or employee of a company, this is the expressions which is under the quotation, officers or employee of a company, applies on not only to the existing officers which already exist or employee, but also includes past officers. Past existing means the present, but also past officers or employees which were just an officers or employees. Either there is two considerations: wrongfully obtained positions of any property, wrongfully withholds the same after the termination of his employment. Not only he obtains the position, but also withholds the same after termination of his employment in those cases. The expression will also include legal heirs or representatives. The expressions, as we find here, both was the expressions officers or employees of the company. It will also include legal heirs and representative. it was held by the court that the penal statutes should not be so liberally construed with the aid of presumptions, assumptions, implications as to rope in for the purpose of prosecution, for the prosecution such person against whom the prosecution is not intended by the statute, not even intended by the statute, and initiation of prosecution should be violative of Article 20 of the Constitution. So there's we find a rule of interpretation, that is, not be so liberally construed with the aid of presumptions. Presumptions, as we know, propositions, certain kind of assumptions or implications, which is kind of hypothesis, which is not so useful. It may be true or may not be true. So it must not be interpreted liberally or in HSA manners as with the aid of presumptions, assumptions, implications as to rope in for the purpose of prosecution against whom prosecution is not intended by the statute, neither it is intended by the statutes and nor it is by Article 21, that is if it is violative of Article 21 of the Constitution. And as we have already mentioned, it must be read keeping in view, construed keeping in view public policy, the rule of public policy. Virtual soft system LTD versus CIT, virtual soft system. These are the cases which we need to know to understand how a penal statute is construed. The question that arose before the Supreme Court in the case prior to the amendments by the Finance Act 2000. It is Finance Act 2000 with effect from 1st April 2003, where what was meant by the words in addition to any tax payable in charging sections 27 subsection 1. What was meant by the word in addition to any tax payable in charging section 27 subsections 1 clause C Roman 3? What was meant by the term total income in explanation for adhering? So virtual soft system LTD versus CIT, this was the case. And the amendments case prior to the questions through that arose prior to the amendments by Finance Act 2000, effect from 1st April 2003. So allowing the appeals, it was held by the court that the statute creating the penalty is the first and the last considerations. Creating the penalty is the first and the last considerations, and the penal provisions must be construed within the term and language of the particular statute. Section 271 of the Act is penal provisions. Section 271 of this particular Act is penal provisions. So here we find the words the term language of the particular statute construed within the term and language. That means literal interpretation or grammatical rule of interpretations. Not only strict but also literal. So, and there are well-established principles for interpretation of just a penal provision. Just a provision has to be construed strictly and narrowly and not widely. So we find certain words strictly and narrowly and not widely, means not liberally, with the object of advancing the object and intention of the legislator. They don't need to advance the object, with the object of advancing the object and intention of the legislation. Then comes Municipal Corporations of Delhi versus Lakshmi Narayan Tandon. What was the act in this case? In this case, the definition of the Prevention of Full Adulteration Act 1954 was construed in the sense having regard to the mischief intended to be remedied. Mischief rule of interpretation, as we have already read. Mischief intended to be remedied. It was held that the sale in the act will include all commercial transactions where under an adulterated article of food was supplied for consumption from one person to another person. Adulterated article of food. So therefore, supply or offer of food to hoteler to a customer when the consolidated charge was made for residents and other amenities include food fell within the definitions. So this was sale under Prevention of Full Adulteration Act 1954. The name title of the case is Municipal Corporation of Delhi versus Lakshmi Narayan Tandon. Then another case is there, Tolaram versus State of Bombay. In this case, Section 18 of the Bombay Rent Hotels and Lodging House Rates Control Act. What was the act here? Bombay Rent Hotels and Lodging House Rates Control Act 1947 was construed, and we will check particular section, Section 18. And what is the title of the case? Tolaram versus State of Bombay. The state is the State of Bombay. The act was also Bombay Rent Hotels and Lodging House Rates Control Act 1947. And what is the name of the plaintiff? Tola. T-O-L-A, Tola, and Ram. Tolaram. Ram is there, last in there, Tola. Tolaram. So this section provides that if any landlord receives any fine premium or like other like sum or deposit for any considerations other than the standard rent in respect of grant, renewal, continuance of a lease in the premise, such landlord shall be punished. So imposes penalty or punishment. It was held by the Supreme Court that the section does not prohibit the taking of money by owner of an incomplete building in consideration. This part is excluded. Section did not prohibit taking of money by owner of an incomplete building, in considerations, because the building was incomplete. So this is an exception or exempted. Conclusion: a statute may in certain aspects be penal enactment, in certain others remedial one. A statute itself may in certain aspects be a penal enactment, in certain others a remedial one. In respect of those provisions which are sanctioned on the pain of punishment for a crime, rule of strict constructions in the limited sense may be applied. In case of punishment for a crime, the rule of strict constructions in the limited sense may be applied. At any rate, as undue effort to construe such a provision liberally to promote the beneficial purpose behind it may be effectually counterbalanced in the consideration that breach therefore leads to a penal consequences. So this was the conclusions. So we have read the constructions of penal statutes with the help of various case laws. So in summary, it is to be said that penal statute, first of all, offences imposing penalties to be strictly construed is not of universal application. It may be of limited application. A statute may be construed. A statute may have penal provisions or remedial provisions. It should be construed accordingly. It should not violate Article 21 or fundamental rights or human rights. It must be construed keeping in view of the public policy. Then after this we find various case laws. In it is said that it must not be violative of any kind of article. It must not be construed with the aid of presumptions, assumptions, or implications. Such a provision has to be construed strictly, narrowly, and not widely. Strictly, narrowly, and not widely, with the objective advancing of the intention of the legislature. So this was all about the construction of penal statutes.